A 74-year-old man named Richard wakes up on a normal Tuesday with a severe headache that quickly turns into a mild stroke. He survives. He is lying in a hospital bed, recovering, confused but alive. 3 days later, his wife of 42 years, Helen, walks into their local bank branch. She needs to pull cash to pay the mortgage and cover a few sudden medical bills. The teller looks at the computer screen, looks back up at Helen, and says, "I am sorry. I cannot let you touch this money. The account is completely frozen." Helen is his wife. They have been married for over 4 decades. But because the account was in Richard's name and he is temporarily incapacitated, the bank legally shuts her out. 2 weeks later, there is a knock on Helen's front door. It is not a neighbor bringing a casserole. It is a court-appointed stranger holding a clipboard, sent by a judge to take a physical inventory of Richard's assets. The state has stepped in. If you are over 65, I need you to put down whatever else you are doing and listen to me very carefully. What happened to Richard and Helen was not a bank error. It was not a scam. It is the default legal process in the United States. If you lose cognitive capacity, even temporarily from a fall, a stroke, or early dementia, the system does not automatically hand control of your life to your spouse or your children. The system assumes control of you. My name is David Taylor from Senior Money Brief. I have spent years untangling the traps that quietly devastate older Americans. And I will tell you right now, this is the single most terrifying risk of aging in this country. It is called state-appointed guardianship. In 2026, the rules around banking and medical privacy are tighter than they have ever been. Without one specific set of papers legally signed before a crisis hits, your family has zero legal authority over your retirement accounts, your real estate, or your body. Instead, a judge who has never met you will appoint a professional guardian. A complete stranger who gets to decide where you live, what medications you are given, and who is allowed to charge hundreds of dollars an hour directly out of your own life savings to do it. You might be sitting at your kitchen table right now thinking, "David, I am legally married. My spouse is my next of kin. My adult children will just step in and handle things." And Lida. That is the most dangerous, expensive lie in American retirement. And it traps families every single day. Let me show you exactly why. Next of kin. It is a phrase we have all heard 1,000 times. It sounds official, does it not? Most Americans over 65 quietly believe that being someone's next of kin is a magical legal key that unlocks doors when things go wrong. You assume that because you have a marriage license, or because your name is on a birth certificate as a parent, you automatically have the right to step in if your loved one gets sick. But here is the brutal truth that nobody tells you until it is too late. In the eyes of the law, love means absolutely nothing. Blood means absolutely nothing. A marriage certificate is not a legal power of attorney. If your husband has a stroke and can no longer communicate, you cannot legally call up his pension provider and change the direct deposit details. If your wife has an IRA or a 401k in her name, you cannot call the brokerage to withdraw funds to pay for her nursing home care. Even if you have been married for 50 years, the person on the other end of the phone will look at their computer, see that you are not the individual account holder, and they will hang up on you. And if you are an adult child trying to help an aging parent, it is even worse. Imagine your mother falls and ends up in a rehabilitation center. You try to call the utility company to keep her electricity from being shut off. You try to pause her cable bill. You try to talk to her Medicare provider to sort out a massive billing mistake. Every single time, you will hear the exact same robotic answer: "I am sorry. I am not authorized to speak with you without the account holder's permission." But the account holder is in a hospital bed. They cannot give permission. This is the exact moment the trap snaps shut. Your family is paralyzed. They cannot pay your bills. They cannot manage your investments. They cannot even talk to your health insurance company because strict federal privacy laws like HIPAA make it a crime for doctors and corporations to share your information without explicit written consent. The people you trust most are forced to stand outside a glass wall, watching your finances crumble, completely powerless to stop it. And when your family runs out of options, they are forced to go to court and beg a judge for the legal right to manage your life. You might think you can just march down to your local bank branch right now and sort this out with a manager who knows you. But here is the terrifying truth. The bank is not your friend in this situation. In fact, the bank is actually your biggest obstacle. Let me explain exactly what happens inside a bank when a senior loses capacity. Most people think the bank is trying to steal their money. They are not. The bank is doing something much more dangerous. They are trying to protect themselves from liability. In 2026, financial fraud against older Americans is a massive federal issue. Banks are terrified of being sued. If a teller suspects you are suffering from dementia, or if a family member walks in and says, "My dad is in the hospital, I need to pay his bills," warning sirens go off inside the bank's legal department immediately. The bank's lawyers know perfectly well that if they let your son or your wife take money out, and another family member complains later, the bank could be on the hook for massive damages. So, they choose the safest option for themselves. They freeze the account entirely. This is called a financial freeze, and it is a nightmare. Your Social Security checks might still drop into the account, but absolutely no money is allowed to leave. The automatic payments for your mortgage bounce. Your property tax check bounces. Your utility bills go unpaid. When your desperate spouse or child begs the bank manager for access, the manager will hand them a piece of paper and say, "We cannot help you until you bring us a court order." And just like that, your family is forced into the court system. They have to hire an expensive attorney. They have to file a lawsuit essentially suing you, declaring you legally incompetent. This process is called conservatorship or adult guardianship, depending on your state. It is not quick and it is not cheap. It routinely takes 6 to 9 months of waiting for court dates. Meanwhile, your bills are piling up. The legal fees easily run $5,000, $10,000, or even $15,000, money that comes straight out of your own life savings. But here is where the trap truly closes. The judge does not have to pick your family. If your kids argue, or if the judge simply feels your family is not equipped to handle your money, the judge will assign a professional, state-appointed conservator. This is a total stranger who is handed complete legal control of your life's work. They get access to your checking account, your pension, and your real estate. And the most sickening part? They are legally allowed to pay themselves out of your money. They can charge your account $200 or $300 an hour just to write your utility checks or authorize a house repair. They can even sell your family home to pay for your nursing care, and your spouse cannot stop them. That is what happens when the bank freezes your money. But it is not just your money they lock up. The next part dictates who actually lives or dies in a hospital room. We just talked about your bank account and your life savings. But losing control of your money is only half the nightmare. The other half is losing control of your own body. Imagine you are rushed to the emergency room after a severe fall. You are unconscious. A critical medical decision has to be made right now. Maybe it is a risky surgery, or putting you on a ventilator, or deciding whether to use a feeding tube. Your spouse is standing right there by the bed, crying, telling the doctor, "Please, do this but do not do that." We talked about this. I know what he wants. Most people over 65 think the doctor legally has to listen to your spouse. But here is the cold reality of the medical system in 2026. Without the right legal document on file, your spouse is often just another voice in the room. If there is any disagreement at all, maybe your adult son from a previous marriage disagrees with your current wife about your care, the hospital administration immediately hits the brakes. Just like the bank, the hospital is absolutely terrified of a lawsuit. If they guess wrong about who should make the call, they get sued. So they do not guess. They look to a rigid state priority list. Or worse, if your family is arguing, the hospital's legal team will petition the state court to appoint a temporary medical guardian to make the decisions for you. Suddenly, the person deciding whether you stay on life support, what aggressive treatments you receive, or whether you are discharged to a substandard state-run nursing facility is a court-appointed stranger. A lawyer who does not know you, does not love you, and has never sat at your kitchen table. They are looking at a medical chart, not a human being. They decide your physical fate. And what if your family just wants to know what your test results are? Because of strict federal HIPAA laws, doctors and nurses can face massive fines and lose their licenses for sharing your medical records with anyone who is not legally authorized. Your own daughter could be standing at the nurse's station begging for an update and be told, "I am sorry, we cannot legally discuss the patient's condition with you. This is not a rare accident." This happens every single day in American hospitals. Families are shattered, fighting in hospital hallways, while a risk management committee dictates your care. It is the ultimate violation of your dignity. Your choices are hijacked by a bureaucracy simply because you did not leave legally binding instructions. The entire system is rigged to take control the moment you cannot speak for yourself. It is quietly waiting for you to fail. But there is exactly one legal shield you can build to stop it cold. One set of papers that locks the state out of your life forever. Here is the good news. You do not have to be a millionaire to protect yourself from this nightmare. You do not need a massive legal team on retainer. You simply need to file one specific set of documents before a medical crisis hits. When you sign these papers, you are doing something incredibly powerful. You are legally stripping the state of its jurisdiction over your life. You are telling the court system, the bank managers, and the hospital lawyers, I have already chosen who is in charge. You have no authority here. This one-paper solution is actually a tight bundle of two specific legal forms. The first is the durable financial power of attorney. I need you to pay very close attention to the word durable. That single word is the most important part of the entire document. A regular power of attorney becomes completely void the exact second you lose cognitive capacity. It turns into a worthless piece of paper right when you need it most. But a durable power of attorney survives your incapacity. It stays legally binding even if you are in a coma, recovering from a stroke, or dealing with advanced dementia. This is the document that forces the bank to keep your accounts open. When your spouse or your adult child hands this paper to the bank manager, it legally forces the bank to let them pay your mortgage, manage your property taxes, and access your retirement money. The bank cannot freeze your account to protect themselves because you have already legally appointed your own financial boss. You just locked the court-appointed stranger out of your savings forever. The second form is your advance healthcare directive. Some states call this a medical power of attorney combined with a living will. This is your medical iron shield. It does two critical things. First, it names the exact person who has the absolute legal right to make medical decisions for you. When your doctor looks at this paper, there is no debate. The hospital administration does not have to panic. Your chosen person has the final say. Second, it includes a strict federal HIPAA release. That means your family can instantly see your medical records, talk to your nurses, and find out exactly what is going on without the hospital shutting them out. It also lays out your exact wishes for end-of-life care, whether you want a ventilator, how far you want doctors to go, and what treatments you absolutely refuse. It takes the agonizing burden of guessing off your family's shoulders. When you have both the durable financial power of attorney and the advance healthcare directive signed and properly notarized, you have built an invisible legal wall around your home. The state cannot touch you. The judge cannot step in. The hospital cannot ignore your spouse. You keep your money, your health, and your dignity exactly where they belong, in the hands of the people you actually trust. It feels like a massive relief, does it not? Just knowing these documents exist changes everything. But here is where I have to warn you. Just knowing the names of these forms is not enough. Millions of seniors think they are protected right now, but they are carrying a worthless piece of paper. Here is the hidden trap that causes people to file the wrong form and lose everything anyway. Many people hear about the durable power of attorney and think, great, I will just go on the internet, print a free form, and sign it at the kitchen table. Stop right there. That exact move is destroying families in 2026. Downloading a generic, one-size-fits-all legal form from a random website is one of the most dangerous financial mistakes you can make. You print it, you get it notarized, and you put it in a drawer feeling completely safe. But you are not safe. You have walked right into a massive legal trap. Fast forward to the day your family desperately needs to use that form. Your spouse or adult child rushes into your local bank branch and hands that generic paper to the manager. The manager scans it and sends it to their corporate legal department. 2 days later, the answer comes back, rejected. Why? Because banks absolutely hate generic forms. The banking industry employs armies of lawyers whose only job is to look for reasons to say no and avoid liability. A generic form downloaded from the internet almost never contains the specific, exact statutory language required by your individual state legislature. A form that is perfectly fine in Texas might be completely legally void in Florida, Pennsylvania, or Ohio. Every single state has its own quirky rules, its own required paragraphs, and its own specific witness requirements. If that generic paper is missing just one mandatory sentence, or if it does not explicitly grant the power to handle digital banking, specific retirement accounts, or real estate transactions, the bank will flatly refuse to honor it. And remember what happens when the bank says no? The account gets frozen. Your family is standing there holding a piece of paper they thought was an iron shield, only to realize it is entirely worthless. You are right back at square one, forced into the court system, handing your money over to a judge and a state-appointed stranger. You cannot afford to play guessing games with your life savings. Your documents must be absolutely bulletproof. They must carry the exact legal wording your specific state demands, or the system will reject them the moment you are most vulnerable. But let me clear up another misconception right now. You do not need to hand a law firm $5,000 to get this done right. The correct, state-specific protection is absolutely within your reach. So, how do you get this done perfectly without getting ripped off? How do you guarantee the state stays out of your business forever? Here is your exact, step-by-step checklist for this week. Here is exactly what I want you to do this week. No delays, no excuses. This is the practical checklist that locks the state out of your life forever. Step 1. Get state-specific documents. Do not type free power of attorney into a search engine. Either sit down with a local, qualified estate planning attorney, which is often much cheaper than you think for just these core documents, or look for the official statutory forms provided directly by your state's government website or local legal aid office. The magic word you are looking for is statutory. That means it is written by your state legislature, and local banks are legally required to accept it. Step 2. This is the move almost nobody makes. The moment you have your durable financial power of attorney signed and notarized, do not hide it in a desk drawer. Take it directly to your local bank branch while you are perfectly healthy. Walk in, hand it to the manager, and say, "I want this reviewed by your legal department and placed on my file today." Let them clear it right now. If there is a problem, you can fix it while you are standing there. Do not wait until you are in a hospital bed for your family to find out the bank has a problem with your paperwork. Step 3. Take your advance healthcare directive and make 3 physical copies. Keep one at home, give one to the person you name to make your medical decisions, and hand the third directly to your primary care doctor to put in your permanent electronic medical record. Never lock your medical directive in a bank-safe deposit box. If you have a severe emergency on a Saturday night, the bank is closed, and your family is completely locked out of getting the paper they need to save you. That is it. 3 steps. You have worked your entire life to build your savings, buy your home, and take care of the people you love. Do not let a completely preventable paperwork technicality hand it all over to a court-appointed stranger who charges $300 an hour just to write your checks. Take control right now, before the system has a chance to take control of you. This is general education, not legal advice for your specific situation. Always confirm your own documents with a qualified professional in your exact state. If this video opened your eyes, do one thing for me. Send it to one person you know who is over 65. The government is never going to call them and explain how this system really works. You might be the only one who does. I am David Taylor. Subscribe to Senior Money Brief, turn on the bell so the next warning finds you, and I will see you in the next one.